All right, good afternoon. This is Criminal Justice Full, and it is August the 23rd I suppose it's 2 o'clock. And we are glad you are here. And are there any personal orders from the committee? Seeing none, Madam Clerk, will you please take the roll?
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chair Gillespie, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
Thank you. Okay, we won't waste any time. We will move already on the number one on the calendar is House Bill 7033 with Chairman White. Chairman White, you have a motion and a second. Chairman White, you're recognized.
Thank you, Chairman Committee. 7033. Are we on Amendment 9509 still?
All right, I have a motion and a second on 9509. All in favor say aye. All opposed, no. The ayes have it. 9509 is attached to the bill. Please, if you'll explain.
Sure. Committee, I took this bill at the request of Speaker Sexton. Basically, all it says, it is, in my opinion, a simple bill. Notwithstanding another law to the contrary, when a defendant has been arrested or held to answer for a bailable offense, the clerk of the court that admits the defendant to bail shall, within 48 hours of the defendant being admitted to bail, publish on the clerk's website a report listing the following information for each defendant: the offense of the defendant, the amount and conditions of the bail, and lastly, the name of the magistrate, judge, or other judicial official, or the clerk admitting the defendant to bail. It basically, we're trying to get accountability so that if someone commits a crime, basically, especially over and over, that we have accountability in the system. And that's technically what it does.
All right, thank you. Any questions for the sponsor? Yes, sir. Representative Hardaway.
Thank you, Chairman. So, Chairman White, it doesn't add any new information into the public sphere. It merely organizes it into a portal to where it's accessible.
Yes, which is on the, what does it say, the website of the clerk, where they put that out so that those who would be interested know what's going on. Accountability.
All right, thank you very much.
You're welcome.
Leader Lambert.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for bringing this bill. And I appreciate Speaker Sexton for introducing it as well, because I think it does add a lot to not only just the public sphere, but to just some transparency on bond, why those bonds are set, how much they're set, who set them. And that's important for, I think, accountability. And you said that in your presentation, but in my district and probably in yours as well, this information is already online. But there are dozens and dozens of counties throughout this state that don't have this information readily available to the public. And so I think it is a definite step in the right direction to help us just understand what exactly, how these bonds are being set and by whom. Right. And then if there are issues that we see arise from that, then that's something that I think, in the coming session, starting in January again, we could potentially address. So thank you for the bill.
Thank you.
Any other questions for the sponsor? All right. Question's been called. We're voting on House Bill 7033. All those in favor say aye. Aye. All opposed, no. Have one no. The ayes have it. Bill moves on to finance.
Thank you, committee.
We're now on item number 2 on the calendar. It's House Bill 7034 by Chairman Grills. Have a motion. Have a second. Chairman Grills, you're recognized.
Thank you, Mr. Chairman. I believe there is an amendment on that bill that was put on in the subcommittee. I want to make sure that amendment is following.
We have to put it on again here.
Okay.
Is that 9502?
That is correct.
That's what I'm showing. Is there a motion? Second. I got a second. There is a motion and a second to put 9502 on this bill. All those in favor say aye. All opposed, no. 950 goes on the bill, or 9502 goes on the bill. Chairman, you recognize.
Thank you, Mr. Chairman. That amendment, all it did was clarify some reference in the bill to the stalking as defined from 36.3.601 to 39.17.315, if anybody cared. Technical correction was what it was. This bill was given to me by Speaker Sexton, and this bill is intended to promote public safety by increasing the penalties for stalking and aggravated stalking. This bill also requires an independent professional mental health assessment of the defendant to determine their need for mental health treatment if the person is convicted of stalking, aggravated stalking, or especially aggravated stalking. The court, however, may waive the assessment if there was an adequate assessment conducted prior to the conviction. If the assessment indicates the need for mental health treatment, then the court shall include that in the sentence. The offender is required to pay the cost of the assessment unless they are considered indigent. As a condition of bail or other pretrial release, the defendant may also undergo an evaluation. The proposed bill takes a comprehensive approach towards enhancing public safety by increasing the penalties for various stalking offenses while also acknowledging the potential underlying health issues that may contribute to such behavior. With that, I stand ready for questions, Chairman.
All right, any questions for the sponsor? All right, seeing none, we are voting on House Bill 7034. All those in favor say aye. All opposed, no. Ayes have it. 7034 goes on to finance, sir.
Thank you, Mr. Chairman.
All right, the next bill is mine, so I pass the gavel to Vice Chair Gillespie.
Thank you, Mr. Chairman. We are now on House Bill 7071. Mr. Chairman, thank you. And Mr. Chairman, you are recognized.
Thank you, Chairman. House Bill 7071, it just quantifies the data and the numbers when we use the term mass shooting in the state of Tennessee so that we're all on the same page and so that the reporting mechanism is consistent. And what this bill does, it requires the TBI to submit a report on mass shootings to the governor, the Speaker of the House, and the Speaker of the Senate by January 1st, 2024, and by each January 1st thereafter. The report must include the number of mass shootings in this state for that year and any other information deemed significant to limiting mass shootings. The definition of mass shooting is as follows. 4 or more victims, excluding the perpetrator, are murdered or suffer serious bodily injury by firearm. The murders or injuries occurred in a public setting. The murders or injuries are not attributable to any other underlying criminal activity or criminal offense, including gang activity or gang offenses. And the murders or injuries are not related to domestic violence, not unintentional, and not police shootings. Puts all that data in a same consistent frame so that the report each year is consistent and accurate. That's the bill.
Thank you, Chairman Halsey. With that explanation, do we have any questions? Representative Johnson?
Thank you, Mr. Chairman. I just want to again say that we have this at our fingertips, but giving it to the legislature, I suppose, is helpful. And my hope in that giving this to the governor, the speaker, and the lieutenant governor, that we actually use this information to take action and not just store it on a shelf.
Thank you so much for that. Are there any other members that have any other questions? The sponsor? All right. Previous question has been called. All those in favor of passing House Bill 7071, to calendar and rules, say aye. Aye. All against? All right, the ayes have it. You are moved to calendar and rules.
All right, we're back on item number 4 on the calendar, House Bill 7073. by Chairman Vaughn. Chairman, you are recognized. Is there a motion? Motion. Motion and a second. Go ahead, sir.
Thank you, sir. Chairman Halsey and committee. I'm bringing this bill today on behalf of Speaker Sexton. What this bill is efforting is a decrease in the revolving door scenario that so many times our juvenile courts and juvenile offenders find themselves in.
Excuse me, can I interrupt you just a second? There's an amendment that's traveling with this. We probably need to put it on.
Yes, sir, and the amendment does indeed make the bill. It's coded 9521.
That's what I have. There is a motion. There's a second. All those in favor of putting Amendment 9521 on this bill, say aye. All opposed, no. The amendment's on. Carry on, sir.
Thank you, sir. This bill extends the jurisdiction of the juvenile court from 19 to 24 for juveniles that are considered serious youthful offenders. You say, what is indeed a serious youthful offender? If a juvenile is adjudicated delinquent for any of the following offenses, then the court must classify the juvenile as a serious juvenile or serious youthful offender. The court may impose any current juvenile disposition, but the disposition must last at least until the juvenile's 19th birthday, and here are the offenses for that. First-degree murder if the child is less than 16 at the time of the commission of the offense. Second-degree murder if the child is less than 16 at the time of the commission of the offense. Rape, aggravated rape, rape of a child, aggravated rape of a child, robbery, aggravated robbery, especially aggravated robbery, aggravated burglary, especially aggravated burglary, kidnapping, aggravated kidnapping, and of course the especially aggravated kidnapping, commission of an act of terrorism, carjacking, aggravated child abuse, aggravated child neglect or endangerment, criminal attempt to commit any of the above offenses, any offense that involves the use of a deadly weapon, or an escape attempt from a youth that is interred at a youth development center. The courts may impose an additional adult sentence after the juvenile turns 19. That includes 4 years for Class A felonies, 3 years for Class B felonies, and 1 year for any other delinquent act listed above. Now, the court may stay the adult sentence. If the adult sentence is stayed, then this bill requires the court to conduct a hearing within 4 months of the youthful offender's 19th birthday in order to decide if the court will impose the stayed adult sentence. The judge may, at that point in time, set aside the adult sentence or choose to impose it. The court shall revoke the stay and impose the additional disposition unless the serious youthful offender has made progress towards their rehabilitation, such as they have not committed another delinquent act, they have not engaged in conduct that creates a substantial security risk, or safety risk. They have met the conditions of their supervision. They have attended school regularly with passing grades, or at least graduated from high school, or they have obtained regular employment if they have graduated from high school. Now then, that's the blended sentencing portion of this bill. This is the transfer portion of the bill. This bill also requires that if the juvenile is 16 years of age or older and commits or attempts to commit first or second degree murder, the court must hold a hearing, and if the court finds probable cause to believe that the child committed the delinquent act and that the child is not committable to an institution for the developmentally disabled or mentally ill, then the court must transfer the child to criminal court to be tried as an adult. This bill provides the juvenile prosecution with rights also to appeal the juvenile court's determination. This is meant as an effort to stop a cycle that we have seen, particularly in West Tennessee, where juveniles are committing crimes in their late teens with the understanding that the repercussions for it will be minimal because their 19-year-old release point is coming soon. So what we're trying to do is deter this, use this as a deterrent, as well as provide more time for victims to not have to be confronted by the perpetrators of serious violent offenses against them from a very short previous period. And that's the basis for the bill. And I'll stand for any questions.
Okay, questions for the sponsor of the bill. When we get a little further into this, we've got some folks who want to talk on this, but I want to make sure that the committee sees what you're talking about and the elements of the bill before we do that. So questions for the sponsor. Representative Johnson.
Thank you, Mr. Chair. One of the things that when you were talking about the mandatory extensions, you cited some of the things: not graduating, not having a job, those sorts of things. What if it's a very young mother who cannot work, so therefore doesn't have a job? Are they going to fall under that mandatory extension? Or someone who didn't graduate, absolutely tried and attempted, but did not graduate. Is that person going to be under mandatory extension when perhaps it was not within their ability level to graduate? So are those kinds of things considered in your legislation?
Yes, ma'am, they are. The issue, will be a hearing within 4 months of their 19th birthday where all the facts would be presented. And that would be when this information would come out.
So I get that the information will come out. However, it doesn't appear they have to take those into account when making the decision. They could decide either way without protections in this bill for young mothers, for people who are going to college and can't work, things like that. It doesn't seem like it's written in and any decision could be made.
If I could, Mr. Chairman, have a moment to review the letter of the bill itself.
Certainly.
Go out of session
We'll see if you can find it.
Do you prefer an out of
Yes.
session with legal?
Yes, sir, I would do
All
that
right.
since they have it right there in front of them.
All right,
in
we're
their
out of
capable
session.
hands.
Michelle Fogarty, Legal Services. As written, the bill states that the court shall invoke the additional disposition if the serious youthful offender has committed another delinquent act, engaged in other conduct that creates a substantial safety risk, failed to meet the conditions of supervision during the determinate disposition prior to the hearing, failed to attend school regularly with passing grades or graduated from high school, or has failed to obtain regular employment if the offender has graduated from high school.
Representative Johnson, you have any questions for legal?
Not for legal, because I think it's pretty clear that it's not in there.
Any other questions for legal? Representative Davis.
Thank you, Mr. Chairman. So in looking at that, it looks as though it's a list. It's not one single thing that you fail to meet. It looks like you have to fail all of those. Is that accurate, or is it just one single item?
I believe if you fail to meet any one of those qualifications, then the court shall invoke the additional sentence.
Chairman Farmer? Okay. Any other questions for legal? Representative Hardaway.
Thank you, Chairman. Good afternoon, my friend.
Good afternoon, sir.
On on the level of delinquency, is there any distinction between what type of offense that may violate the juvenile? In other words, can it be the most minor offense?
As written, it says committed another delinquent act.
Okay. And in terms of graduation from high school, does it make any reference to GED or a substitute for a diploma?
No, sir.
All right, thank you, ma'am.
You're welcome.
Any other question for legal?
Not for
Representative
legal.
Johnson.
I'm sorry, not for legal.
Okay.
Just- I have
Any
one
other
more
questions for
to come back.
legal? All right, we are back in sessions. Representative Johnson.
Thank you. And I just feel it's really important to report back from Knox County. Our juvenile court judges do not support this bill. Our adult court judges have stated multiple times that they believe that the expertise lies with the juvenile judges and that they are the ones. The juvenile judges do transfer some folks over to adult court when they feel that's necessary, but the adult court judges feel that it is important that those with the most expertise make those decisions. And so in addition to that, we also have the situation where this is going to cost, it's going to be huge cost to our county. And because the law says that juveniles have to be out of sight and out of sound of adults, it's going to cause a problem with the sheriff's office when transporting young people to court. Where are they going to maintain them unless they have adult days and juvenile days? Are we going to need more courtrooms, more judges? We currently are still backlogged from COVID with our judges. And to add this burden to them when they feel it's not their expertise, they are asking for this not to happen. And so I really feel like we should respect those juvenile judges that have been doing this and understand this for a long time and let them make those critical decisions instead of sending it over to folks who haven't worked with juveniles for the most part and have no expertise in working with juveniles for the most part. So I just think it's really important that I bring how the feelings from my county to this topic. Thank you.
Go ahead.
Thank you, Mr. Chairman. I'd like to point out that the only people that will be transferred out of juvenile court into criminal court are 16 and 17-year-olds, which are charged with attempted or actual commission of second or first degree murder. Those are the only people that we're talking about that would be transferred into the criminal system. The rest would remain with the juvenile court.
Representative Johnson.
And
I'm sorry.
no, that's fine.
I do understand that. And unfortunately, I don't have those numbers with me, but the juvenile courts have given me what those numbers will be. And the adult courts have said they have no idea how they're going to do that, especially when with these juveniles, you often have only 72 hours where you have to have a hearing. And that's really going to throw off the dockets according to judges.
I think you just made a beautiful case for the reason that we need deterrence out here. We have too many children creating too many serious violent acts on our streets. And if we can add a deterrent into the system, then I think this is what we need. So I agree with you. Thank you.
Representative Johnson.
Juvenile crime is down 57% over the last 10 years. I know there is one tiny piece of data that some folks are picking out of this to make their case, but we have graphs of the data right here that shows a steep drop from 2009 to now. But thank you.
Representative Davis.
Thank you, Mr. Chairman. And to the sponsor, as I understand it, it says the bill authorizes juvenile courts to retain jurisdiction over a person until that person reaches 24. So the juvenile court still has the ability to keep that serious delinquent offender in their system as the presiding judge. Is that accurate?
Go ahead.
Yes, ma'am, that is correct.
Okay.
And they would still have access to all the same programs that they had up until the age they were of 19.
Okay. And right now, if a 16-year-old is charged as an adult, they go to an adult court, correct?
Go ahead.
Not necessarily, well, about 1% of all offenses get transferred to adult criminal court.
Right, but that occurs now.
Correct.
Yes.
But
Okay.
it's at the juvenile judge's discretion.
Correct. And so, but the other thing I would like to see that the judge did have more discretion with regard to that list of, instead of making it, I would like to see it more permissive. I would like to see that judge be able to have that discretion, especially with regard to employment, because we don't know what the market is doing or if they have the ability to be employed. And then also with regard to their diploma, their high school diploma, I would like to see some discretion with that and then change that language from mandatory of shall to be a little bit more permissive. But I
Understood.
appreciate your bill.
Any other question for the sponsor? Vice Chair Gillespie.
Thank you, Mr. Chairman and sponsor. Thank you for bringing this. Speaker, thank you for bringing this. We do have a problem in West Tennessee. This is a part of the puzzle part of the solution. It is not the entire solution, but we do have a problem, and this will make our community, my community, safer. And so I just wanted to put that on the record and make sure everyone knew that regardless of what national stats are out there, unfortunately, there is a juvenile problem in the Shelby County area, and it is increasing. It has not decreased. And this is a great way to go after these violent criminals, these violent juveniles, and give them more punishment, because they're doing it over and over and over and over again with this revolving door in our criminal justice system, specifically at juvenile court. So again, thank you, sponsor.
Representative Fritz.
Thank you, Mr. Chairman. Thank you again, sir, for your courage to bring this bill. I know it does take courage to address these top topics. I appreciate that. My only holdup with it is some of the prosecutorial discretion at home. But again, I do want to thank you for bringing it.
All right, if it's okay, Representative Hardaway.
Thank you, Chairman. I appreciate you bringing the concept of blended sentencing, but I do not support the bill as written. And I just heard from a colleague in Shelby County something that's contrary to the data that I'm looking at. Can you tell us your source of data that you're citing on juvenile crime?
Representative or Chairman.
It's my understanding through the DA's conference that our juvenile crime, violent juvenile crimes, is more than doubled over the last 2 years. Sorry, somebody's trying to spam call me, sir.
Okay. I'm hearing 2 years and 10 years. But if we said 2 years, that would take us back to 2020 or 2021. Is that right? And that would put us in the middle of the pandemic. Is that right?
Correct.
And would put most of our children in the house. So I would suggest to you that the last 2 years is not enough of a period to make this judgment. So the question would be, if we looked at the pre-pandemic trend and the post-pandemic trend, that, and I've seen this in everything from finance to sales projections, we cut the pandemic itself out because it's not a realistic version of day-to-day life in America. So I think maybe we're on the same page, except I'm giving you the whole page and saying that the 10-year trend, yanking the pandemic and that aberration where it failed because children were in the house, that when it came back, it's still trending down.
Yes, sir.
Well, to my revered colleague from Shelby County, there were some people foretelling of the fact that our children needed to be in school and didn't need to be held out of school during this time, where they could be receiving education and social interaction, but instead they were allowed to run free, which was an issue that the chickens are coming home to roost on. I can tell you that without a doubt that our streets in Memphis are not as safe as they were 5 years ago. We have there's too many anecdotal, and if it's not based on arrest, then my question is how many people are arrested for offenses now that, because for whatever reason, we hear from policemen that they arrest the same juvenile several times in the same day. So as we try to do something to curb this violence that is indeed affecting the quality of life for an entire population, from the poorest of the poor to the elites, everybody's experiencing and suffering from this plague that we've got of violence. And we need to do something. If we just sit back and say, it's going to get better. Surely it's going to get better. We're past the pandemic. I think that it's time for us to take some type of action to where we implement policies to see if they'll work to where we can turn the tide. For us to sit back and say, well, you know, this young murderer needs to be out on the streets because, well, they tried to get a diploma, but they didn't. And so we can't hold them anymore. But they actually took someone's life within 24 months prior. That just does not seem right to me. And I know that people can pull statistics from whatever source they want to prove whatever they want to. But the fact of the matter is we have experience. I have leaders of communities in rural communities in West Tennessee talking to me about how they can get more state money to have more juvenile detention facilities because they have a problem on their streets. This is an attempt for this body, because when it comes down to it, with regards to crime, we get to do two things. Well, with any issue, we get to pass laws and rules and get to spend money. And of course, people who don't abide by laws, the laws don't affect. That's the misfortune of where we are in today's society. But if we can have someone pause and think and say, hey, as opposed to me getting out Christmas of 26, it may be Christmas of 30 before I get out. Maybe, just maybe, they'll think twice about pulling that trigger. And then on the other hand, incarceration serves two issues from my perspective. And again, I'm not a criminal justice expert, but the first part is for rehabilitation of the offender, and the other part is segregation and separation from their victim. And I think this accomplishes each of those. So that's why I brought the bill. I know we've got experts who may or may not agree with me, but I understand it won't be the first time that me and an attorney have disagreed about something. So,
Yes, sir. And we don't disagree on the need for blended sentencing. This ain't it. We had a bill in sub, I believe it was sub or full, with Chairman White, Mark White. And it made sense to me. It made sense to most of the judges, the adult criminal court judges and the juvenile court judges around the state. It made sense to most of the DAs around the state. And this august body said that we needed to take it to summer study so they could be brought up to par on blended sentencing. I would suggest to you that bill, if that bill was before us now, I'd be beating the drums. I'd be jumping up, hollering, hallelujah, because that's the kind of juvenile justice reform that will work. I think after we listen to the experts, we will find that the automatic transfers that we have, that the impossibility, it's not going to be difficult. It's going to be impossible for us not to get sued on a regular basis because the constitutional rights of these juveniles are going to be violated, trying to hold them in a facility that's built for adults to be together and not built to segregate the juveniles from the adults. They're not going to have the programming because the juvenile court system is where the expertise is. That's where the experts are. That's where the experience is. The adult criminal justice system has programming for adults. And I dare say that the Department of Corrections is not a Department of Corrections when you look at the recidivism rate. And if you look at those who are more likely to reoffend, you will see that it's juveniles, not juveniles, but the young adults who are most likely to reoffend. There's a reason. It's because they don't have the gray matter, the part that helps them control impulse, helps them to make rational decisions. That's not fully mature yet. It's a science. And everyone has recognized it. We've got states that have had the version of the blended sentencing that Mark White's bill had, which I supported. I believe Chairman Gillespie supported it. And say it again, most of the juvenile court judges, most of the DAs, and most of the adult criminal judges supported that bill. This is not it. This bill is not ready for prime time. But thank you for listening.
Vice Chair Gillespie? Oh, okay. Without objection, there are some folks that'd like to testify. If that's all right with everybody, we'll go out of session for just a little while. Let's see, Travis Claybrooks, Ashley Sellers, Zoe Jamal, Jasmine Miller, and Glenn Cherry. I think we have 5 seats up here. Yes.
There happens to be an expert on youth sentencing in the audience. Is it possible to add someone?
I don't care.
Okay. Preston Ship.
Huh? Did they sign up? Do I have everybody whose name I called? All right, if you want to, one at a time, if you'll pull your microphone close to your mouth and make sure the little red button's on. And please introduce yourself for the record, and then whoever wants to start first, go right ahead.
I'll start with my introduction. I'm Zoe Jamal from Disability Rights Tennessee.
My name is Travis Claybrooks with Rafa Institute.
Hi, my name is Jasmine Miller. I'm a staff attorney with the Youth Law Center. We're a national nonprofit that works on youth justice and child welfare issues, but I'm actually based here in Nashville, Tennessee.
Mr. Chairman. Now,
There you go.
Mr. Chairman, good afternoon, members of the committee. My name is Jeff Cherry. My first name is Glenn, as introduced, but I go by Jeff. I was a Metro police officer from 1991 until 2002. I have been a practicing criminal defense lawyer since 2002, having served as Tennessee Association of Criminal Defense Lawyers past president and its current criminal justice development chair. Thank you.
Okay, thank you. Each of you have 3 minutes. I didn't make that rule, but that's what we live by. So go ahead as you wish.
All right, I'll kick us off. Thank you for having us here today. This bill, I think as we've heard already, has a lot of moving parts. There's a component that maintains the current transfer process, a component that creates a serious youth offender scheme, and a component that creates a new mandatory transfer scheme, and I believe also a component adding an appeal process. So there's a lot of different things to talk about, and I think sometimes it can get a little bit confusing which piece we're talking about at the same time. As I understand it, the focus of this bill is to provide a way for courts to address issues of serious youth offenses committed by older youth, and in particular concerns about youth who may reoffend. But the scheme that's proposed today is it's so much broader than that. There is no lower age limit, for example, in terms of who is being considered in the serious youthful offender scheme. So we could potentially be bringing in, 10 or 11-year-olds. And yeah, we don't want any 10 or 11-year-olds doing aggravated burglary, but aggravated burglary is going into your neighbor's garage and taking a lawnmower out. That's aggravated burglary is in the way that it's defined, particularly in Tennessee. And I know a lot of people are concerned about the heinous offenses and all that, but I'm saying this list is not confined to the things that most people would think of as the most serious crimes. Additionally, this blended sentencing scheme, it allows for young people to be held for longer than adults would be for the same crime. And I do believe that there was an attempt to fix that, but I would just let folks know TCA 371137 includes a mention there that young people are not supposed to be held for longer than adults would be for the same offense. But this here, in part, I believe C of the current draft of the bill that I have at least, talks about young people needing to be sentenced until the age of 19. Now, if you're a 10-year-old, that means that you would be sentenced until 19. That's 9 years, plus the additional adult sentence that you're being given, the disposition to the Department of Correction, that starts to be longer potentially than what an adult would serve on a similar type of offense. This one-size-fits-all approach in terms of the serious youthful offender scheme, I'm just concerned that we are taking a really delicate issue and just kind of taking a hammer to it. And I believe that that may just be a result of the fact that we're on a pretty rushed timeline in terms of trying to get something together. But the bill as written, I have a coworker who was in the juvenile justice system and is now starting law school next week, which we're extremely excited about. And under this particular bill, as I believe, legal confirmed earlier, she didn't complete high school because she had a baby. And according to the way that this is currently written, she would have had to go to the Department of Correction, even though she has had really an exemplary life since becoming involved in the juvenile justice system. And that just doesn't really seem fair and balanced in terms of, I think, what a lot of folks in this room and on this committee want to see for our young people who are in need of rehabilitative services.
Okay, thank you. Can you pass the baton to who's next?
I'm happy to go next. Thank you. I want to give a little background as I did my introduction on behalf of the Tennessee Association of Criminal Defense Lawyers. This December, I will have been married for 30 years. I have lived in Middle Tennessee for the entirety of my life. I have 3 grown children, one of which is a 2nd grade school teacher, and we now enjoy a 5-month-old grandson. I want our community to be safe. I want the community that my children, my family, my friends, my colleagues across the state of Tennessee live in to be safe. My college roommate that I went through the Metro Police Academy with was a police officer for a period of time, and he left to become an FBI agent. The latter part of his career, he was assigned to the Memphis field office. We're still very close. He just recently retired. I speak with him often. I understand through our discussions with him and my other colleagues that there are serious problems with serious crimes involving juveniles in that particular area, and I've heard it mentioned by a couple of you here today. It was asked yesterday during the subcommittee to one of my colleagues, what would Tactile propose in regard to this legislation? And I would say to you all here today that it is important, after my 30 some odd years of service in our community, that we have the stakeholders involved in decision-making processes such as legislation involving blended sentencing and mandatory transfer. It's important that the juvenile court judges, the trial court judges, the district attorneys, the public defenders, Tactile, the Sheriff's Association, the TDOC, the DCS, our victim advocacy rights groups, and our mental health community weigh in on what the effects of this legislation is going to be and what can be made better that is not included and what needs to be taken out that is included. I will not go back and rehash the things that I agree with necessarily that I've heard, but I appreciate the questions of Representative Johnson, of Representative Hardaway, and again of Representative Davis about juvenile judges' discretion and what their role plays in our justice system and the importance of what they see and have experience in dealing with young people as it relates to some of these issues. I just want to echo one of the issues about blended sentencing, and I appreciate your comments in regard to that. The question was posed by one of you as it relates to what is another delinquent act that would invoke the mandatory provision under the blended sentencing. And delinquent act under the juvenile code is any offense that if committed by an adult would be an offense for a child, anyone under the age of 18. So a shoplifting offense, a Class C trespassing offense, a Class C disorderly conduct offense. Any of these offenses would trigger a mandatory imposition of that additional time frame. So there are multiple issues with the language or the inartful language that exists that if more time was given and the stakeholders were involved and had a say, legislation could be enacted that is going to be purposeful and meaningful as opposed to what we have before us today. Thank you for allowing me to be heard.
Okay, thank you, sir. Who's next?
I'm Zoe Jamail from Disability Rights Tennessee. Thank you for having me here today. I just want to take a minute to comment on something that the sponsor said, and he said that it's time to take some action. And I understand that there is a desire to address a problem that is perceived in this state. However, that doesn't mean that it's the time to take just any action. It has to be thoughtful and effective action. And what is being proposed here today is not going to be effective in deterring youth crime, and in fact, will likely lead to more reoffending. We know that transfers to the adult system yield more offending, more recidivism, almost 30% increased risk of reoffending for youth who are transferred to the adult system. Okay, now I want to talk a little bit about the serious youthful offender portion of the bill and how that might affect youth with disabilities. There is nothing in this bill that allows discretion to consider a youth's disability prior to designating that youth as a serious youthful offender. I want to say that again. There is nothing in this bill that would allow a judge to consider a youth's disability in determining whether or not to sentence that child as a serious youthful offender. That's a real problem. We give judges discretion because they are in the best position to determine what is best for society, public safety, and the youth in front of them. I want to talk a little bit about some of the criteria that would put a serious youthful offender into the adult system after having completed their juvenile portion of the sentence. So we heard that if you do not graduate high school, that can put you into the adult portion of your sentence. There are barriers to education for youth who have committed crime. Lots of barriers to education. We come across youth who have been without schooling for years because of their involvement in the juvenile justice system or the adult system. To penalize a child for not being able to access education when there's barriers to that access that have nothing to do with the child's desire to access it, that's a real problem. In fact, this legislature passed a bill last session that makes it harder for youth to re-enroll in school after they have committed a crime or gotten in trouble with their school. It allows the director of schools not to re-enroll that child. If we want kids off of the streets and not committing crime, we have to ensure their access to education and special education for youth who have disabilities. And to punish them for not accessing it when we are not giving them the supports that allow them and ensure that access just seems counterproductive. And if this is a bill that is in the interest of public safety and we want to make our communities safer, this is not the way to do it.
Okay, thank you. Yes, sir.
Thank you, members of the committee, for allowing me to speak. My name is Travis Claybrooks, founder and CEO at Rafah Institute. We're a local nonprofit here in Davidson County. Over the last 5 years, we have been running a restorative justice diversion program in partnership with Davidson County Juvenile Court. Over that 5-year period, we have processed or handled over 160 cases, all felony cases. We have worked with over 150 victims, over 200 young people. Of the young people who have completed this process, less than 5% have gone on to commit a new crime or be convicted of a new crime. Compared to Davidson County, Tennessee's 40+% recidivism rate. Over 90% of the people who have been harmed in those cases that we work with express satisfaction, a sense of justice, a sense of healing with the process and the outcome. One of the failures of our current system, criminal legal system, is that people who have been harmed by crime, their voices and their needs are not heard, not respected, and not met. If incarceration made us safer, we would be the safest nation in human history. But we know that that's not true. Unfortunately, when we are faced with situations like what may be happening in Davidson County or in Shelby County, sometimes we don't feel that we know what else to do. And when we don't feel that we have options, we try to do more of what we're currently doing that isn't working. Perhaps that is what is happening now. We don't know what else to do. I'm going to argue that we do know what else to do. Restorative justice is a viable option that works with people who've been harmed to help them get their needs met. It works with young people who have caused harm. We do everything from home burglaries to homicides to address the driving causes of their engagement in criminal activity. What are the underlying factors? What's happening to you? What has happened to you? What we don't hear from people who have been harmed by crime, especially violent crime, is that I want to see the kid go to jail. We do hear, I'm pissed off, I'm angry, I'm mad, I hate that this happened to me. But what we hear most is, I don't want this to happen to me ever again, and I don't want this to happen to anybody else again. And so we deserve a response. They deserve a response, a process that allows the driving causes of what happened to them to be addressed, to be confronted. What we do hear from young people when they're given an opportunity and a process to do it, they step into a restorative justice process and they say, I did something wrong and I want to take responsibility for it and I want to make it right. These people come together in a conference and they sit together 2, 3, 4, 5 hours at a time and they talk about what happened. They talk about the impact that it had on them. They get to ask and answer questions of one another. They get to pursue justice on their own terms and they get to pursue transformation, personal transformation on their own terms in a very well supported process. We can no longer say that we don't know what to do. My fear is that this legislation undercuts our opportunity to continue doing things like this, things that work, in favor of doing more of what doesn't work. Thank you.
Thank you, sir. All right. Before other questions, if I could ask one, and then I'll get on to it. Mr. Claybrooks, you and I talked for a little while, and you mentioned that you're expanding into Shelby County and Memphis. And also, we talked about, I'd like the committee to hear, I said that I'm very doubtful of these pat answers that we've heard for years on what causes, what are the central root causes, what's the rot come from, where does it begin? And I don't buy all the things that I'm told. And you told me some very interesting things. Would you expound on that, please?
Absolutely, yes. We are presently expanding to Memphis, Shelby County with this initiative. There's opportunity to turn the tide of what's happening and what's been happening in that community. I'm a former law enforcement officer. I have very keen interest in reducing crime. Who wants to be pistol whipped? Why do young people cause harm in the first place? We know hurt people. And yeah, we hear that and we say that. And we all have had experiences where we have had disparate circumstances in our life. We've all in some way maybe experienced some kind of poverty or had some barrier to a critical resource or access to a critical resource that we needed, be it housing or education or healthcare in some way or some sort of other social support. What makes a difference in most people's life in terms of being able to be resilient in those moments, in those times, is having safe, stable, nurturing relationships that help buoy you through those times. And unfortunately, so many of the people that we work with, so many of the young people that we work with do not have those supports. Mom is self-medicating. She's got mental illness. Dad is dead or in jail. And you got 13, 14, 15-year-olds trying to figure out how to feed their siblings. And so they go out and they rob. And so they go out and they do. They have their own stuff happening in their heads. One of the reasons we think our program works so well is because we surround these young people with just that safe, stable, nurturing relationship that walks with them through that journey and through that process. What incarceration does, we have baked into prisons all the things that have driven young people to crime in the first place: poverty, violence, isolation, shame. These are all the things that are driving them there. That's what they see in their community. That's what they're living around. Why would we then, as a response to their behavior, in response to those conditions, put them in more conditions that not only replicated, but replicated on steroids, if I could use that metaphor? And so, again, we must have different processes. We must be more creative. We are sophisticated enough as a society to think differently about how we respond to our children when they are doing heinous things. And there is no doubt, there's no argument as to the heinousness of what is going on. But incarcerating them for infinite number of years is perhaps more heinous.
Thank you, Mr. Chairman. Mr. Claybrooks, I just want to say thank you for stopping by my office to explain all this to me also. And as you go into Memphis, I wish you much luck and success. I just want to thank you for what you're doing for the state of Tennessee.
Thank you for your time. I appreciate it.
Other questions for these folks? Yes, Representative Johnson.
Thank you, Mr. Chairman. Jasmine, we talked a little bit yesterday. I think it's important, we can't stress this enough, that with transferring some of these folks to adult court, when we're talking about victims of human trafficking, and we're talking about the traffickers that have control of them and tell them, a lot of us feel very concerned about traffickers saying to people, well, you can't go to the police. You can't tell what is happening because you're going to be tried as an adult. And so no one's going to believe you. Because of this law, you'll be tried as an adult and you'll be in prison for the rest of your life. Is that a concern?
Absolutely. And thank you for bringing that up, Representative Johnson. And I want to be clear, this issue around young people who have experienced sexual exploitation or other forms of abuse, I think that issue is raised for me both in the serious youthful offender scheme, which is the blended sentencing part of this bill, as well as the adult transfer part, because in neither of those schemes is there an ability for a judge to consider, has a young person potentially committed one of these acts as a result of their contact with someone who has been exploiting them. And unfortunately, I think we see a lot with our young women and our girls who are coming into contact with the juvenile justice system. A lot of them have a history of having been sexually abused or a history of commercial sexual exploitation. And sometimes as well, the fact that they have come into the contact with the juvenile justice system, it makes them more vulnerable to people who are looking for vulnerable people to exploit. And it does raise a lot of concerns for me when there is no ability to consider the fact that someone might have done something as a result of involvement, with human trafficking, with these abusive relationships, that we're not able to consider it at all. I'm not saying that young people shouldn't be held accountable, but to say that we cannot consider that is a real big problem. And then additionally, when we're talking about the serious youthful offender and also the transfer to adult court, where are the young people getting the services, right? So we have some really great nonprofits all across the state of Tennessee that are working with people who have experienced commercial sexual exploitation. And I'm concerned that when you are talking about, in the serious youthful offender scheme, we're talking about potentially committing someone to the Department of Corrections. Well, if the Department of Corrections custody, they're not connecting, right, with a lot of those nonprofits who are doing really wonderful work. And similarly, I would say on the adult transfer side, if they're in adult facilities, they are not connecting with some of the really amazing services that people have worked very hard in this state to ensure exist to support our young women and girls who have been victims of exploitation.
And just one quick thing, because I just want to make sure that I heard you correctly. So what you said to me was this bill would allow youth to be held longer than an adult would be held for the same crime. Is that correct?
That is correct. I do believe there was an attempt to remedy that between different versions of the bills. But when I looked back at the most recent amendment that I had, so there is a code provision currently that says that for young people, you cannot give them a sentence that is longer than a sentence that an adult would have. But at the same time, we have this provision here, C, that says, the court may impose any of the dispositions set forth in this section upon a juvenile classified as a serious youthful offender, provided that the disposition must not end before the serious youthful offender's 19th birthday. And so I think particularly for the younger you are actually under this scheme, the more likely you are to have a sentence that is longer than an adult would get, which I think is kind of the reverse of what most people would think, right? That perhaps if a 10-year-old is coming in and something awful has happened and they have been involved in one of these, these offenses, that probably there's something else going on there, right? If you have a 10-year-old who's coming in on something like this, maybe it's exploitation, maybe there's a situation where they have been left on their own and they're just trying to survive all of that. Usually we would think of those as circumstances where we would say, let's wrap you with services. Let's potentially look at getting you foster care services, right? Let's think about all of those things. And unfortunately, this scheme gives the judge little to no wiggle room, right? Where they're basically having to say, you have to be supervised by the juvenile court until you are 19. And I know that it's a little bit confusing the way that it's written, but there are some real concerns I have about the ability of the court to properly, adjust services over the course of these, potential for some of these young kids, 7 years, the ability to adjust that, because currently the juvenile court can't just make orders when it feels like it and just say, well, before I had you in DCS custody, and now I'm putting you on community service, and now I'm putting you on probation and whatever. We have rules in terms of the way that this works. And so what I'm worried about, and I don't think this is the intention of the bill, but the way that it's written currently, when that young person comes into contact with the system, the judge has to make a dispositional order that lasts until they are 19. And they have very little, they can't say, well, this part is this and this part is the other, and we can move you down to a less restrictive environment as time goes on because you're doing well. That's not in there. I would love for it to be there. I think that it might actually be the intention of the drafters that be something that would be available to courts, especially for some of these young people who might be on long terms of supervision, but it's just not there right now.
Okay, thank you. I appreciate that explanation. Hopefully with all the side conversations, everyone heard it. Thank you.
Representative Hardaway.
Thank you, Chairman, and good afternoon to you all. Ms. Miller, we were banding about numbers, statistics, in particular, the last 10 years versus the last 2 years, and national data versus Shelby County data. Would you comment on that for me, please?
Yes, I would be happy to. And sorry, I had my printout of my graphs, but I think I left them at the table. But I might have the TBI still pulled up. Yes. So, I went and looked at the Shelby County data, and this is just pulled straight from the TBI's website. And so, if people have concerns about what the data says or doesn't say, the TBI probably would be the better people to answer it. But I did go through and look at what are the, reported number of offenses for youth 18 and under, youth 18 and 24, and older folks in Shelby County going back. I think I went possibly 20 years. And I think what we see actually is that the peak in terms of when there were the most reported incidents, and this isn't arrests, this is reported incidents to the TBI of crime in Shelby County. The peak for youth 18 and under was 2010. that was the year when there was the most, according to the TBI data I have in front of me, that was the year that there were the most reported offenses. And in the time since 2010, we have seen, for the most part, year over year, a decline in the number of offenses that are committed by youth 18 and under. And that's not to say that we shouldn't care about the fact that there continues to be crime. Of course, we should care about that. But what I am saying is that if we look at this data from the past 10 or 20 years, we're not really seeing this explosion in number of incidents reported to the TBI. And I think that you were talking a little bit with Representative Vaughn earlier about sort of the 2-year versus the 10-year. And so, yes, there was a really dramatic drop in 2020 and to a lesser extent 2021 from the prior trend line in terms of the decrease in youth crime in Shelby County. And so, we've kind of course corrected. We've gotten back on that trend line. That has meant that over the past 2 years, there has been that uptick. So it is true that in the past couple of years, there has been an uptick in youth crime in Shelby County. However, the number of offenses that we were seeing in Shelby County reported in 2022 are roughly the same or less than the number of offenses that we were seeing in 2018 or 2019. So I do think that whenever we're talking about crime data, it is really helpful to try to get that broader picture. And then I would say as well, it is also true that for 18 to 24-year-olds, we have seen this decline over the past 10, 15 years in the number of offenses reported. There are other statistics that show, for instance, that we're seeing a pretty big uptick in crime committed by people who are older than 55. And that we've maybe had some issues trying to address, lowering crime rates for folks who are 25 to 34 or 35 to 44, that we're seeing, it's still a decent number of incidents and not really a drop among those populations. But to me, I think what that calls into question is, if we are seeing this, decline in reported incidents for our young people, the 18 and unders, and then also the 18 to 24-year-olds, maybe that indicates that if those young people are coming into contact with the juvenile justice system is maybe effective in reducing crime, as opposed to some of the adult offenses where we're seeing that it's staying the same or it's going up, and relying on that system to deal with recidivism seems perhaps not the wisest move based off of what I have now. Of course, I'm just saying what I see here on the website. I have the TBI data up. I'm sure there are more conversations and more viewpoints, and there might be different data points. There might be, local upticks in crime. There might be upticks in particular types of offenses. I am not in any way saying that there are no problems with crime. But I would say that if this bill is in response to the thought that there has been just a dramatic increase in youth crime in Shelby County or statewide or in any other jurisdiction, that what I have in front of me right now from the TBI website does not seem to indicate that sort of level of response might be warranted, and that it might actually be better to take a deeper dive into what specifically is causing some of the fear in communities, what specifically is causing harm, trying to understand, do we currently have services that address those harms or not? Okay, and then coming back after that and saying, okay, maybe we do need to adjust the sentencing scheme because maybe there is something missing that our current law doesn't allow us to do, and we need to fill that in. But to just go straight for changing the whole sentencing scheme without taking those steps, it does concern me, especially with the concerns. I think I would echo the concerns that the member from Tactile mentioned about stakeholder feedback.
Thank you, ma'am. And I want to reiterate, you said TBI is your source.
Yes, I have it pulled up in front of me.
And the trend, when you take the aberration of the pandemic years where children were locked up in the house, the trend continues downward after that.
Yes, we only have 1 year post-pandemic, so I do want to be, clear about that. But we are not seeing that the crime in 2022 is particularly higher, and in fact is a bit lower than 2018 and 2019.
All right. And when we look at, I asked earlier, I want to make sure that we speak to your ability to either cite Memphis Shelby stats or Memphis Shelby statistics, or to extrapolate from the national. Tell us which ones
So
you're doing
I am
here.
looking at the TBI data for Shelby County right now. That is what I'm talking about.
All right, not a national trend. This is about Shelby County.
This is the TBI data for Shelby County, yes.
All right, just a couple of more, and then if you don't mind, Mr. Chairman, I want to ask Mr. Claybrook a couple of questions. But on the, because this is probably, members, this is the most consequential legislation that we're going to consider in terms of juvenile justice reform. This is it. And we will either make a big mistake and disrupt the system to where it does more harm than good, or we're going to do something right. And I would suggest from the experiences that I've had sitting with my colleagues all these years, you like I want to do something right. We all agree about the concept of blended sentencing being long overdue. However, there's the science, and then there's the judicial discretion that we are talking about versus the mandatory transfers, which is the art. So the art and science of putting all this together, where does this bill fail?
I would say there are a number of issues that I are potentially unintentional and due to the timeline that people have been operating on that may not reflect the intent of the bill. And so as written, I can only speak to my experience and what I'm reading here, and others may have different opinions. As written, I do believe that this would be very difficult for any court to implement, just because there is some lack of clarity even around, okay, we have potentially a young person who's on a term of 6 years of supervision. How do the review hearings work? There's not necessarily great clarity about that. I'm sure someone could kind of jury rig something to try to implement this law if it was passed, but you generally would prefer for it to be clear as to what is intended. And as to all the processes. So there's that layer of just sort of the processes and the drafting. And then I would say the additional layer that really concerns me is the discretion around the imposition of the adult portion of the serious youthful offender scheme. I think that's been raised by members already, so I won't repeat it again. But there are some real concerns about that discretion being gone, because when we're writing legislation, you can try to write out every single wild exception that could possibly happen, right? You could try to write a list of 20 different things, 30 different things to make sure that you never accidentally send someone to an adult facility who shouldn't be there, who everyone maybe would think shouldn't be there. You could try to do it that way. Or you can keep discretion and you can let the juvenile court make decisions based off the information that is provided to them by their district attorney and by the child's representative. I tend to think that going towards discretion, you want to give a little bit of guidance, of course, but I tend to think that going towards discretion is a much more efficient way to legislate and to avoid some of these potential unintended consequences.
Representative Hardigan, could you do one more? If you've got another question, I know you do, and I've got to move on.
Yes, sir. I'd like for, Mr. Claybrook or anyone that wants to take it. We're at 4%, we being America, United States of America. 4%, want to be exact, 4.2% of the world population. We are we have 20% of the prisoners in numbers we're only second to communist China in terms of numbers. So having said that, anybody that wants to jump up is, does anyone agree with me that incarceration by itself is not a deterrent, and we need to address some of the underlying issues in order to show how a civilized society can rehabilitate, and even before rehabilitation, can prevent our young folks from entering the system?
Yeah, I can speak to that. Certainly, we represent a small number of the world's population and a large number of the world's incarcerated population. And again, I say, if that made us safer, if that deterred, and the research shows us that it doesn't deter. We hold in the restorative justice context that personal transformation is the greatest deterrent. It's the greatest deterrent to causing harm. You change. It's a changed person. And that's what we go for. And when people want to do that, they do that. When people have an opportunity and the resources to do that and the support to be able to do that, young people and adults, they will. When they have those resources. Where I believe that we are challenged as a society is that we don't have enough of those processes in place. We have been sold a bill that says, this is the way that you should be responded to when you do something wrong. You should be punished and you should go to prison. And the reality is that not only doesn't advance transformation for a person who's caused harm, it doesn't satisfy the need for justice and healing for people who've been harmed. You only need to walk into a parole hearing after a person has served 25 years in prison and see that family who's been harmed, who's had a loss of life, there, 25 years later, just as broken, just as hurt, just as torn, just as unhealed as they were on the first day. To know that 25 years of prison didn't do it for them. It didn't do it for them. So we must be more imaginative. We must be more creative. And the beauty of, I think, where we are today is that we do have other things that we know can work. We just need space and time to be able to do those. And my concern is that this undercuts that opportunity. I would hasten to say that a restorative justice option is just that. It's an option for a person who's been harmed. They have the opportunity to take it. If they don't want it, when we get those kinds of cases, we send them back. They say, no, I want to go through the criminal legal system. I want to prosecute this kid or this person. We send it back to court. If a young person doesn't want to participate in it, they're not at a place where they're ready to say, I did that thing or whatever, we send it back to court. So it just gives more options for people to experience justice and healing and transformation, which I think gives us more than what we currently have.
Okay,
Thank you, Chairman.
we're running along here. Representative Towns.
Mr. Chairman, thank you. Each of you all, thank you for your testimony. I'm impressed by the knowledge that you all have shared, that all of y'all, that hopefully will allow us as, leaders to try to craft something that's going to be beneficial to the whole lot of the state. And I'm equally more impressed that we have two law enforcement officers, former law enforcement officers on the board. You all have seen quite a bit in your tenure, in your time in this community, as each one of the other two ladies as well, but it's very important to me because you work with it. It's not that you are shunning away from that crime exists. You know it does. You've dealt with it face to face, okay, up close and personal. And for you to be here to try to help us to gain insight as to how do we go about changing this monster. And as has been stated by my colleagues so eloquently, obviously there's no one thing that will do it, but I've heard some things today that could help us, that can assist us and point the ship in the right direction. And one of the things that crime is, I think that nobody wants to, I say it often, criminals don't want to be victimized by crime. No one does. It's a human thing because the flesh can't take that. But what we do in our country is we're angry when we respond to crime. It's hard to respond to crime with love because we're human, but we're taught to turn the other cheek and forgive just another, but it doesn't make any sense to the flesh, okay? So consequently, the laws come out where we are punitive, and it's only punitive on one side. I mean, our money is spent wholesale on punishing, and there is a place for punishment. Don't misunderstand me. There's a place where you get your butt tightened up, punished, incarcerate, all the above. It is. But only traveling down that lane is not netting us what we should get in this society. What I would love to see, Mr. Chairman, is out of this, and I know this is everything is provoked based upon an incident that happened in our state that went around the country. It's been happening everywhere. It's not a Tennessee thing. It's a countrywide thing. This country is more violent. Our kids are more violent. And it's because of a number of things. I say often, there's a game called, what is this crazy game these kids have been playing for a long time? Who remembers Dr. C. Dolores Tucker? When she began to talk about the music and the filth that was in the music. The games that these kids play, see, the movies and the things, our kids are slowly indoctrinated to be violent with everything in our culture because of freedom. Freedom is the thing that we all want and we don't want to give it up. But if it's not guarded with your children, you can do damage to your children before they're 15, 16 years old. And they're right there in your house. The access they have on the cell phone, the filth that they have on the cell phones, and you're paying for it. You don't know what they're doing on the cell phone. Okay? All of it's not good. You got perverts out there. You got all kind of perversion out there. Now, to a young mind, it may seem what? Exciting. It may seem like something new, but there's a slow burn of programming of what the reality is for them. Okay? And it's a thing where we won't solve it with just guns being banned or longer incarceration. However, some of that has to be done, not banning guns or anything, just limiting sensible laws, because the Second Amendment right is something we all believe in. But some of these things have to be done, but by itself, it's not going to solve it. Now, I'm in Shelby County. The sponsor of the bill is in Shelby County. This gentleman is in Shelby County, Hardaway, as well as Gillespie's in Shelby County. Love to talk to you about what it is you're doing. You don't need to come down there without talking to us. We need to be involved in it because I think it's a good piece, okay, at some point. And Mr. Chairman, I would think also that it would be good if we could take some time. I don't know where the bill is going, but I think the bill could be improved based upon what Chairman Hardaway said with some other bills out there. This bill needs a little TLC to make it a better bill. The bill needs a little TLC, and from what I've heard from some of you all here, we have the ingredients to add a little TLC to the bill to make the bill to something more palatable and something that could work a little bit better for our state, you know. But we're upset. But old folk would say, haste makes waste. You can do it too fast and you'll mess it up. And we don't want to do that because it's very difficult to undo when you messed up what we should not have done. You know, old folk would always say a stitch in time, say what? Saves 9. It seems to me they had more sense than we do. They didn't have all these degrees, the PhDs, the BSs, and the masters of nonsense degrees, and they had more sense than we do today. They made the world a better place. Okay, they had everything under control, but all this scientific, sophisticated nonsense, all these big long words behind your name, and you can't, like to tell you, like my grandmother said, you can't pour piss out of a one-room window out of one boot. Don't have any sense today. So maybe we need to go back and talk to our elders and figure out what's going on because they raised good children. They raised respectful children. The society was under control then. Old folk with no degrees. Mr. Chairman, thank you.
They paid a lot of money for that degree for masters of
You know what?
nonsense.
You know what?
All right. Thank you folks so much for being here. I appreciate your time. We're going to go back in session. Sponsor of the bill, if you'll return to the podium, please. Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And I was listening both while in the committee and then in the back on the television. I stepped out. And I appreciate everyone that came and testified. But I don't know if maybe some of them were testifying on the original bill or in the actual amended bill. But on the amended bill, I mean, first and second degree murder are transferred to adult court. And I can understand the objection. I agree with that decision if we were to pass this bill. I think those are the most heinous crimes and someone else has literally lost their life. For all the rest of these crimes, I mean, I was hesitant about this bill because it keeps juveniles in juvenile court longer and gives a juvenile judge the incentive to not transfer some to adult court. That's what juvenile judges have told me for years and almost 20 years of practicing criminal law is if they had an option to keep a child in juvenile court longer, they would hesitate to transfer that child to adult court. So I understand what the folks that were up here testifying were saying, but I disagree because the way this bill is drafted for all of these serious offenses, it allows the juvenile judge to keep the child in juvenile court to have additional rehabilitation instead of just transferring to adult court. And as long as they stay in juvenile court, they are not convicted felons. They are not convicted in an adult system. They do not have an adult record. They remain in juvenile court. So this bill appears to me to strike a very good balance. Chairman, this affects your community very heavily and communities around you. I appreciate you carrying this bill. I mean, it is a balance I've been looking for years, and some of my friends from Shelby County and other counties, we have struggled with this issue for years on trying to get this balance right. This allows these juveniles additional time in juvenile court to try to be rehabilitated so long as they don't commit new crimes after they're adults and progress up through the criminal justice system. We don't want that. None of us want that. So I just wanted to highlight that because in the amended version, I was sitting over talking with legal counsel. It's just very different from what was described from the testimony we heard. So, and sometimes that happens. Maybe the amendment didn't get in the system right or something like that. But with the amended version, that's what the bill does. So thank you, Mr. Chairman.
Any other questions for the sponsor? Chairman Farmer.
Yeah, I want to make one comment is, as I understand it, according to the AOC, I believe under the amended version of this bill, there would have been only 20 juveniles that would have been automatically transferred statewide last year. So when we have this conversation about, well, our jails are going to be overloaded, we're going to have this mass exodus from juvenile to the adult prisons. I don't think that's going to be the case with regards to the amended version of this bill. And as Leader Lambert said, that discretion, for the most part, is going to stay with the juvenile court judge if he or she wishes to keep that juvenile in juvenile custody. So I didn't want to make that comment. It really wasn't a question, but if you have anything you'd like to say, I'd like to hear it. Thank you.
Okay, go ahead.
Thank you, Mr. Chairman. One thing that I would like to clear up too is that while juvenile crime overall may be going down, it is rising in Shelby County, and those are TBI statistics, violent juvenile crime. So whenever you look at it from that standpoint, let's remember that's what we're talking about here. But I thought it was interesting when I was looking through social media earlier, saw something come up from Metro. It's not always about Shelby County. However, that is the nearest and dearest place to my heart. So that's what I have friends that have been affected by crime, but just saw where the Metro Nashville PD said for the 4th time this year, a 16-year-old Nashvilleian has been arrested for car theft. 4th time. Tuesday night, he was driving a Hyundai stolen in Clarksville on the 5th of August. He refused to stop for officers. An NPD helicopter followed him home where he was arrested and a second stolen vehicle was also found. This speaks to, that's the 4th time and we're in August. Our system, this fellow, Mr. Claybrooks, I welcome him to Shelby County. We've got a problem that's big enough for all hands on deck. What this bill seeks to do is provide another tool in our toolbox to take a comprehensive look at all of these items. Because we can say, hey, that's a youthful offender. He didn't know what he was doing. And so he just stole a car for the 4th time this year and led the police on a chase. Doggone it, he'll grow out of that phase. There's got to be some consequences, more than the available consequences we have at our disposal. And this wasn't even classified as a violent act, but there was public safety and endangerment involved with it. So I understand that some people have different worldviews. I understand that. People can disagree. I don't get my feelings hurt when people who don't think like me disagree with me. Having civil discourse and debate is about people who disagree discussing a solution. So I would ask this committee to advance this bill further so that we can at least we can be doing something to stem the tide that we see building with these violent juvenile offenders. With that, I'll hush, Mr. Chairman.
Representative Hardaway.
Thank you, Chairman. And I don't want my colleague to hush because I want to talk to him. Okay. And there are things that, and I'll say this again, there's an art and there's a science to juvenile justice reform. This bill fails on both. What I don't understand is, and I share your passion with crime. My family has been victimized by crime. I have any number of constituents, as you and I talked about before, where I've attended funerals and I've had to comfort mothers who have lost children. I've had to comfort children who have lost parents, brothers, sisters, cousins, etc. However, I have to stay focused on the difference in furthering a justice system that's transactional versus transformational. We can lock folks up until the cows come home. But if we haven't given them the proper rehabilitation programs, they will come out worse than they went in. That's the part, one of the parts where this bill fails. The juvenile court system, all of the judges that I've talked to, and you may have talked to some that said they support this bill. I haven't asked you that. You may have talked to some sheriffs who have said they support this bill. I haven't asked you that. You may have talked to some DAs who support this bill, okay? Or some public defenders who support this bill. I haven't found those folks. I haven't found any of the stakeholders in Shelby County who support this bill for the reasons that I cited earlier. And I got a million more reasons. I was trying to stay with the basics. But these are the stakeholders. These are the experts. These are the folks who've been at this forever. They know what works. They meet across the state. They meet regionally. They meet nationally. And they compare notes. We have blended sentencing in some of the other states, but they do it the right way. We have not put the art and the science in this legislation. And I would ask you the question when you heard one of the witnesses testify that there's the potential that the courts would be compelled to deliver justice unequally between the young adults and the juveniles, rather, and the young adults, that you could potentially end up for the same crime giving a 7, 8-year-old more time than an adult would get for the same crime. Not only would that be violating our state statutes, but it would seem to me at some point we're going to get pulled into court if your bill, as is, was passed, pulled into court for constitutional issues. And I would ask you to respond to that, sir.
Well, I think that's one misperception or I wouldn't call it a misrepresentation because the young lady who brought that up was obviously very bright and very passionate about what she does. And so, but it may be a case of, like Leader Lambert said, reviewing different versions, but the youthful transferred piece, it's tied to the existing state statute. So a 10-year-old, the only way they can be transferred is if they've committed, the only offense they'll be transferred for is murder. And so I understand that people have been looking at this in different ways, but I don't believe that we'll have an issue with this bill, sir.
All right, Mr. Chairman, I'm going to ask that you go to our legal counsel, so we'll have a straight answer on that, because evidently I don't know, and with all due respect, I'm not sure if the sponsor knows how that process could work out.
All right, out of session for legal.
Michelle Fogarty, Legal Services. Could you restate your question, please, sir?
Is it possible under the amended version for a juvenile, a young juvenile, to end up being assigned more time than an adult? That you could have a 7, 8, 9-year-old that would end up with more time in custody than an adult for the same crime?
Are you speaking about the blended sentencing portion or the transfer portion?
What I got in that? Yeah. The bill in total, ma'am.
Under the blended sentencing portion, it applies if a juvenile is adjudicated delinquent for an offense, and the offenses in that list are primarily A, B, and C felonies. Under our sentencing scheme in Title 40, Chapter 35, the minimum sentence for a Class A felony is 15 years. The minimum sentence for a Class B felony is 8 years. And the minimum sentence for a Class C felony is 3 years. I don't know that I can give you an exact answer because it depends on the facts and how old the child is, what they're charged with. I will say that there's nothing in this bill that requires the juvenile court to sentence them to custody. It doesn't say that they have to commit the child to the department's custody. It says they can use any disposition that's currently available, which would include probation. It does not prevent, for those eligible offenses, the court doing judicial diversion. That in that instance, the child would not be adjudicated delinquent, so the blended sentencing serious youthful offender requirements would not apply. And it also does not impose upon the prosecutor's discretion as to what offense they petition. But if a 10-year-old was charged with murder and they were kept under juvenile court jurisdiction until they were 24, I'm not the best at math, that would be 25 years. So you're right up on the minimum sentence for a Class A felony range 1 offender. I hope that answers your question.
Well, you got some of it. Let's go with a Class C. Is there a circumstance where a juvenile, we go with 7, 8 years old. I've been to juvenile court and had to speak to detainees who were 7, 8 years old. Let's say that it was a Class C. Is it possible, using the amended version, for that juvenile to receive more time than an adult for the same Class C felony?
If they were how old when they?
Well,
8. Yeah, I don't know that I can answer that question. It depends on the facts, how they were charged, and if they did judicial diversion or. It's based
Okay,
on the
we're going to
facts.
say no to diversion.
I don't know.
And I think, Mr. Chairman, that within itself is an answer, that there is no definitive answer. And that's the danger of the bill. So, thank you, ma'am.
Any other question for legal? All right, we're back in session.
I'm on the list.
I promised
Brief
Representative
statement.
Johnson for a quick question.
Yeah, I just wanted to make a point. I don't like to leave things open. And ideas were put out there, I want people to understand that the witnesses here were on the amended bill. They're very much aware of the amended bill. Thank you.
Okay, Vice Chairman Gillespie.
I call the question.
All right, question been called. We are voting on House Bill 7073. All those in favor say aye. Aye. All opposed, no.
No.
Well, the noes were louder, but I believe the ayes have it. Bill passes on to finance. Thank you. We are on item number 5, House Bill
Thank you, Chairman and
7013
committee.
Thank you.
by Leader Lambert. Leader Lambert, you're recognized.
I think I got it.
Have a motion, have a second?
Mr. Chair. Mr. Chair.
Oh, I'm sorry. I am sorry. Chairman Farmer, you're the sponsor of the bill.
And I just, I appreciate that, Mr. Chair. It's one of the, it comes out of the governor's package, members. So if I could get a motion and a second on it.
Yeah.
And I do have an amendment today on this. It's a very minor corrective.
I'm showing 9551, is that correct?
That is correct.
And we have a motion, is there a second? Have a second on the amendment. We're voting on amendment 9551 to attach to bill 7013. All those in favor say aye. All opposed, no. Ayes have it. The amendment goes on the bill.
And thank you, Mr. Chair. And members, and what this amendment does, it literally just changes, it has it's a 72-hour requirement, and it changes it to, from 72 hours to 3 business days. What this would allow for is for courts to report to the TBI the results of a judgment or something along the line of that, to get that, and it's reported electronically, so TBI, the database would be updated. This is coincides with the governor's executive order 100, which was put in place back in May, I believe. So this has been going on. It's not a problem. We don't have staffing issues because it's submitted electronically. The statute used to read 30 days, but that was when things were having to be handwritten and mailed, and before the internet and computer and everything like that. So this is just codifying an existing executive order that's been in place. This will expedite communication between our courts and our Tennessee Bureau of Investigation with regards to background checks and things like that. So,
All right, any questions for the sponsor? Seeing none, we're voting on House Bill 7013 as amended. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves on to counter the rules. Next is item number 6, House Bill 7027 by Leader Lambert. Leader, is there a motion? Motion, a second? You're recognized, Leader.
Mr. Chairman, I hope this is a bill that all of us can come together in a bipartisan fashion. Several years ago, before the majority of us on this committee were in the legislature, the state made the decision, and I think this was unwise, to stop paying for mental health evaluations for misdemeanor defendants. These are individuals that the state of Tennessee has charged with a crime, and they are misdemeanors. The state chose to just pay for mental health evaluations for individuals that are alleged to have committed a felony. So at this time, this bill, if passed, would go back to the way it was before and get those folks the help that they need. The fiscal note on this is about $2.5 million a year out of a $56.2 billion budget. Surely we can make sure that these folks get the help they need. I will tell you that this is guaranteed to save some lives and also change lives. One of the things that I've seen happen in almost 20 years of practicing law again is that many folks start out with small problems, small mental health issues, just like we talked about in the last bill. And when they go undiagnosed, when they go untreated, when they do not get the help they need, it progresses into much larger problems. And so this will just help us get ahead of it.
All right, you heard an explanation of the bill. Any question for sponsor? Representative Hardaway.
Thank you, Chairman. And to the bill's sponsor, I bring the same energy in support of this bill that I brought in opposition of Chairman Vaughn's bill.
Thank you, Representative Hardaway. I'm sure he won't take it personal.
Any other questions for the sponsor? Question been called on the bill. Voting on House Bill 7013. All those in favor say aye. Aye. All opposed, no. Ayes have it. Bill goes on to calendar and rules. We're now on item. Well, okay. I have dyslexia. I am sorry. That was for House Bill 7027. it moves on to finance, Mr. Sponsor. Which brings us to item number 7, which is House Bill 7041, also by Leader Lambert. Leader Lambert, you recognize. Is there a motion? Motion and second. Go ahead.
Thank you, Mr. Chairman and members of the committee. And this is a very, very simple, straightforward bill. It just says that the TBI will present us with a study on human trafficking. They're to have that done by December 1st of this year and then every year thereafter. This is an opportunity to drag this issue into the light. We did a study on this about 10 years ago, and there are lots of organizations that do this. But I trust the TBI's numbers really above and beyond just about anybody's. I mean, they are working on this issue daily and have done so for many years. And so this is just a chance for us to get the best data that we can possibly get.
Question been called on the bill without objection. You rescind it. All right. Representative Hardaway, recognized.
Thank you, Mr. Chairman. I want to thank the leader for voicing his support for the accuracy of TBI data.
All right. Any other questions for the sponsor of the bill? Question's been called once again on the bill. We're voting on House Bill 7041. All those in favor say aye. All opposed, no. Ayes have it. Moves on to calendar and rules. That brings us to item number 8, House Bill 7026 by Chairman Zachary. Chairman Zachary, you have a motion and a second. You recognize.
Thank you, Mr. Chairman. Mr. Chairman and committee, I have an amendment drafting code 9481.
That's what I show as well. We have a motion and a second on drafting code 9481. All those in favor say aye. All opposed, no. 9481 moves on the bill. Go ahead, sir.
Thank you, Mr. Chairman and committee. Members, this is a result of the working group that the governor pulled together over the summer. Currently in 3917 1316, if you have been adjudicated mentally defective or mentally institutionalized, you are not allowed to purchase a weapon. Currently, as TBI pointed out, there's a gap in ticks that juvenile information, those juveniles who have been adjudicated mentally defective or mentally institutionalized, when they turn 18, now their record is clearing. And so this bill simply cleans that up and ensures that their health records and their mental health records are pushed forward into ticks. That's all it does. With that, I'll be glad to answer your questions.
All right. Any questions for the sponsor? I have one, sir.
Yes, sir.
And then I will get to you. If a juvenile at, say, age 14 goes through a period of thoughts of suicide, goes to mental health for counseling, stays in counseling for 2 or 3 years, does that record follow them like this record would follow under your bill?
Great question. This only applies to 16 and up, and it only applies to those youths who are adjudicated mentally defective or have been mentally institutionalized. That's the only application.
Okay, thank you.
Yes, sir.
Representative Johnson.
Thank you, Mr. Chair. Not really a question. I just hope that one day we can all do something about that term mentally defective in the language. That's really horrific. So. I'm for the bill.
All right. Any other questions for the sponsor? We then, without objection, are going to vote. Oh, I'm sorry, Representative Hardaway. Go ahead.
Yes, sir. Thank you. And two things. One is, will this information be available to the public?
Go ahead, Chair. No, it will not.
It doesn't change any of
correct.
that. And the second is, there is a path for the individual to receive a evaluation that could restore their ability to carry a weapon.
Oh. Go ahead.
Thank you, Mr. Chairman. That process does not change. And actually, if you look, Representative Hardaway, at the end of the bill in Section E, it actually notes that process. Thank you.
I apologize. Representative Johnson's head is blocking your arm, so I cannot see when you raise your hand.
I just want to make sure I was recognized before I speak, Mr. Chairman.
I'm sorry.
Thank
All
you.
right. Any other questions for the sponsor? All right. Question been called on the bill. We're voting on House Bill 7026. All those in favor say aye. All opposed, no. Ayes have it. Moves on to finance.
Thank you, Mr. Chairman and committee.
That brings us to item number 9, which is House Bill 7030. But we have a motion and a second. Do we have a sponsor? Yes, we do. Chairman Grills, you are recognized, sir.
Thank you, Mr. Chairman and committee. I do believe we have an amendment that we probably need to put on there that actually makes the bill.
I have 9524.
That's what I have too, sir.
Motion and a second on the amendment 9524. All those in favor say aye. All opposed, no. Ayes have it. 9524 is on the bill. Go ahead, sir.
Okay, thank you, Mr. Chairman. And what the amendment does, it took 7030 and 7031 and put those together. It was theft of a firearm by 16 and 17-year-olds and burglary involving a firearm by 16 and 17-year-olds, allowing the courts to transfer them, the juvenile court to transfer them to adult court and be charged as an adult.
Okay, any questions for the sponsor? Representative Johnson.
Do they already have the discretion to do that?
Yes, sir.
Okay, yes, Mr. Chairman. Thank you, Mr. Chairman.
Thank you.
They do not, this will be an additional crime that they would have the authority to transfer. It's not in that part of code. However, the transfer process is already in code. We are not doing anything to that.
Thank you.
Any other questions? All right, seeing none, we are voting on House Bill 7030. All those in favor say aye. All opposed, no. Bill passes, goes on to calendar and rules. If you're a no, please register with the clerk. That brings us to item number 10, House Bill 7049 by Representative Parkinson. Is there a motion? Second. Is there a second? All right, you got a motion to second. I didn't hear it. Representative, you're recognized, sir.
Thank you, Mr. Chairman. This bill creates a Class C felony of knowingly inducing or coercing a minor under 18 to commit theft of a firearm or robbery or burglary offense involving theft of a firearm from a residence or a motor vehicle.
You've heard an explanation of the bill. Are there any questions for the sponsor? I like your bill, sir. Question been called on the bill. We're voting House Bill 7049. All those in favor say aye. All opposed, no. Ayes have it. If you're a no, please register with the clerk. Moves to finance.
Thank you, Mr. Chair.
Thank you.
committee.
That brings us to item number 11, House Bill 7037 by Representative Davis. There's a motion and a second.
Still motion.
Sponsor, you are recognized, sir.
Thank you, Mr. Chairman. Honored to be with you today. Appreciate you guys. I know our good friend Bill Beck was on this committee, so I wanted to make sure I mentioned that. And it's an honor to be here for the special session. Just a little bit about this bill, and I'm actually planning to pull it off notice, but we met with TBI this morning. We were under the impression there was a backlog in the system, and then we learned more about the process today. Got an understanding of that 72-hour bill that you guys just passed as well. And so we realized this isn't going to be necessary in the end. One other thing we wanted to mention was we've learned that some of the mistakes that are actually getting incorrectly submitted to the TBI, and you've probably heard of this before, is from the consolidated court reporting system is what we need. And that's what our understanding is to truly rectify some of those issues. So just encourage you, the members of the committee, to look into that in January and just think about that. I know it's been mentioned a long time. So I hope to do some more good with this committee in this session. But I think this is it for me. And with that being said, Chairman, I'm going to take this off notice.
All right, thank you, sir. We have multiple comments, sir. Leader Nambers.
I just want to say this, and look, I've been here 11 years. Representative Johnson and I came in together 11 years ago, and we've seen a lot of people kind of come and go. You've handled yourself like a consummate professional in the short time you've been with us. And it takes a lot to go from a subcommittee to a full committee and pass a bill through that process and then meet with interested parties and say, hey, look, this is already being handled by another bill or something else. And that it shows, again, I appreciate the way you've handled this bill. And in the short time you've been here, it has been a pleasure to serve with you, sir.
Thank you, Leader. Appreciate that. And that's sort of how I operated on the Metro Council, and was happy to bring that to you for a brief moment here at the legislature. And it's been an honor. So thank you.
All right, Representative Davis to address Representative Davis.
Thank you, Chairman. And that's what I was going to say, from one Davis to another Davis. Thank you for being here and thank you for your service.
Thank you so much. Appreciate that.
Representative Hardaway.
Thank you, Chairman. And we appreciate you, man. You've done some things. I don't think you got the proper hazing, but
Needed to get to
yeah,
the floor. I needed to be on the
we
floor
can
for
get
that,
to you
man.
between
Could
now and
only get it up
tomorrow,
one
I
level.
guess. But the way you've handled yourself and the statement you just made about recognizing that their circumstances aren't as you thought they were, and your legislation may not address them. That's something for us to listen to and try to replicate somewhere down the road. But I'm going to ask, if you're called back to testify on a bill that does the remedy that you suggested,
sure,
don't expect this kind reception.
Okay. I'll expect to be beat up a little bit. And
All right.
Thank you.
yeah, thank you so much. I appreciate
Representative
that.
Towns.
Mr. Chairman, thank you. And from one Davis to the other Davis, are you all some kin to Sammy Davis?
We'll have to look that up. I don't know. Yeah.
Yep.
Little Tennessee
Are
cousins.
you all any kin? You guys could be kin now.
It's possible.
Had to get your own roots and find out the TV program, okay? Thank you, man, as well.
Thank you,
All right,
Representative.
is there a
Appreciate
motion
it.
to adjourn?
Thanks so much.
So moved. All right, we're closed, subject to the call of the chair.
Been 11 years though.
Well, you gavel the bill.
That's how long it's been.